Hi everyone, Ben Fox here with Huber Fox. Anybody remember that classic rock song from the 60s? What's your name? Who's your daddy? Is he rich like me? Well, the band that wrote that song, the Zombies, probably didn't know they were talking about a major issue that pops up in trust and estate litigation. Today, we're talking about paternity and adoption and how it relates to inheritance rights. First, let's define paternity. Paternity refers to the legal recognition of a person as a parent, typically in the context of establishing a biological or legal relationship with a child. This relationship status carries with it certain rights and responsibilities, like custody, child support, and yes, inheritance. Figuring out who are the children and who are the parents is vitally important, whether you're dealing with a will or a trust or even someone with no estate plan. This problem is typically a lot easier when you have a will or trust because you can specifically name your children. But even then, I've seen self-interested and self-proclaimed children come out of nowhere and seek a slice of the pie. Their efforts, thankfully, are commonly thwarted by a strong estate plan. The problem becomes far more challenging when someone dies with no estate plan, and the law requires the decedent's assets to be distributed to heirs in succession. The problem becomes even more complicated when a child is adopted into another family. When a biological parent gives up their child for adoption, that biological parent is no longer recognized as the parent. The adoptive parent is the legal parent. And here's the critical part. Once the biological parent is no longer the legal parent, the adopted child can no longer inherit from that biological parent, unless there's a will or trust that says otherwise. But again, even crazier, because there is one exception involving step parents. And this is going to sound like a Dr. Seuss tongue twister, but here we go. If the biological child lives with the biological parent for any period of time and is later adopted by a step parent, and that step parent marries the other biological parent, then the adopted child can still inherit from the biological parent. Is your head spinning yet? Let's bring it back to basics. If you're a parent or an adoptive parent, make sure your estate plan is up to date. If you had a child adopted out, but you still want that child to inherit from your estate or trust, your best option is to create a valid estate plan to carry out your wishes. Don't assume your biological child will automatically inherit. If you're an adopted child who wants to better understand your inheritance rights, you should contact an attorney and make sure that you know where you stand. No matter who you are, you should be proactive and get your questions answered now by contacting our firm. Otherwise, someone down the road might be asking that question from the 60s. Who's your daddy?